Rob Crain is a legal expert, lives over in the Dallas area, and he deals a lot with issues like this involving large judgments against particular companies. I want to see what he thinks about it. Hey, Rob, glad you joined us today on the Common Sense Show.
Yeah.
Rob, tell my listeners, if you will, we've got a little time here, that exactly what happened. What was Andrews suing about? She sued a hotel, and I think there was a peeping Tom. Can you give us the facts that tell us exactly what happened?
You bet. There was a gentleman who was a stalker of Ms. Andrews, and he had been fairly active. This was not the only hotel in which he had been attempting to video her. And what he did on this particular incident was Ms. Andrews was in Nashville covering the ESPN football game with Vanderbilt. And she was at the Marriott. He knew she was going to stay at the Marriott. So he went into the Marriott hotel, got on one of the internal phone lines, the house phones, and called the front desk from, their own phone from within the hotel and asked for Erin Andrews' room. And when they patched him to Erin Andrews' room, he knew that her room number would pop up on the display of that internal phone. So he then had her room number. He then went downstairs and asked to get the room next to her room. And from there, he went to her door, removed the peephole device, and then used a video recording device to then videotape her while she was changing clothes. He then put it out on the internet, and it went viral.
Well, I wonder, did when he asked for her room, did you follow the transcript enough to say, he didn't say, I want to be next to Erin Andrews, or he said, I want room 212 or I'd like to stay, because I've done that before. I've got particular rooms that I like in hotels. I'm up in New York a whole lot, and in a number of locations. I know over the Gulf Coast we've got some great hotels, resort hotels, and I like a corner room that has a particular view. So when I call to make the reservation, I'll ask for room 214 because I like that corner view, maybe like the balcony or something like that. Do you remember from what you know of the trial, did he ask to be next to Erin Andrews, or just ask for a certain room number?
According to his testimony, which was interesting because initially when he was deposed, he pled the Fifth Amendment to protect his rights in any criminal proceedings, which he ultimately pled guilty to and ultimately served nearly 3 years in jail for this. But according to his later testimony that he gave in deposition just before trial, he said that he went, once he got the room number, he then went down to the floor where Ms. Andrews' room was, and then researched what number room was next to her. So he went and found that information on his own, went downstairs with that information, according to his testimony, and asked for that particular room number. He did not indicate that he said, I want the room next to Erin Andrews' room.
And why that's important for my listeners, I want them to know, and I want Rob to comment on this, that we're getting, I think there's no doubt about the guy. This guy's a scummy guy who admitted and overwhelming proof that he spied on her, filmed her, videoed her, and just a real lowlife. But it's a question of, does the hotel have liability? And so if the hotel is only meeting the request of a particular room number because the guy likes the view, or I'll give you an example. My wife is deathly afraid of riding elevators. She got stuck in an elevator when she was 12, and so as a consequence, we always ask for the very lowest floor. And in several hotels we stay in, we like the view, so we ask for room 214, such hotel. That's an issue, I would think, that comes down to the liability of the hotel when they're just complying with a renter's wish for a certain room number. You see what I'm saying, Rob?
Absolutely. And I don't have all of the testimony, unfortunately, not having sat through it all. I don't know if there was any additional evidence that the plaintiffs had indicating that her name was specifically used in other contexts. But I do know from the reading of his testimony, that's what he testified to.
Now, so he goes ahead and he must be standing in the hallway. What kind of a peephole he doesn't drill in the wall. Then he goes into the lock and looks that way, or how does he get a view of the room?
Essentially, what he does is it's, from what I understand, it's a common peephole that you'd be able to look through if you're on the inside and look out, be able to see who's out there in the hallway if somebody knocks on your door. My understanding My understanding is he actually removed that peephole from the door and then used his phone or similar recording device to then record through that hole that was then in the door.
I see. And she was filmed without any clothes on, is what the testimony showed, and so she sued. So then she sued, obviously, this fella the stalker, and then she sued the hotel. And what was her theory against the hotel? The petition that she alleged that there was more cooperation from the hotel staff than what I've read from Mr. Barrett's testimony, the stalker. And her theory is that they were negligent in not protecting her privacy where she was staying and allowing public access to somebody like this to come into a place where she had rented a room and essentially take advantage of the public information they provided the stalker and allowed him to get access to her. So it was a negligent theory that they did not properly protect her personal information. I know that you are I don't want to say plaintiff's lawyer. I don't like that term, plaintiff's lawyer, but you handle major cases representing plaintiffs. You do the really big cases, the huge explosions, that kind of thing. And I'm a lawyer by training, and I've handled some major plaintiff cases in the past. I don't know. I want your opinion on this, Rob, and give me just a balanced opinion. I don't know about you, but I would be a little leery, or I'd be concerned if I were representing Erin Andrews or someone in the similar circumstances. I filed a lawsuit, and I'd certainly go strongly against the guy that, doing the peeping. But I'd kind of be a little leery about, I'd sue the hotel, but I wouldn't be nearly as confident against the hotel because, as you said, the staff was friendly and the staff bent over backwards to help the customer. They should check the guy out. Well, I guess to check him out, we can do it just like get TSA to do a background check to stay in a hotel room or go through metal detectors or, it's a question of how far a hotel goes. A hotel is supposed to be friendly with their staff, and as I've said, on any number of occasions, I've asked for a specific room. As a lawyer that handles cases like this, would you be a little concerned about your case against the hotel? That's the question I'm asking. And before you answer, Rob, if you can give me time for just a quick little break, I want to tell our listeners, talking to Rob Crain. And by the way, you can go to crainlewis.com. Rob is a major expert at major litigation involving huge disasters. That's crainlewis.com. About sportscaster Erin Andrews, very popular ESPN sportscaster you see all the time, who her privacy was invaded. Someone drills through a peephole or looks through a peephole and films her without any clothes on. Jury gives her $55 million in her lawsuit. Rob Crain's my guest. He is a Dallas legal expert. His website is crainlewis.com, and we're trying to put in perspective. Rob, before we took a break, I pointed that question to you. Would you be less confident about judgment against the hotel versus against the individual that did the peeping, based on the fact that most of the things they supposedly did were kind of, to me at least, are in the normal flow of a hotel trying to take care of it? It's customers and potential customers.
You bet, Jim, and you make a very good point. And one other fact I do need to insert here is just taking a quick look at some of the additional records. The clerk who provided the room to the stalker testified he never heard a request for Ms. Andrews, or a room next to Ms. Andrews. However, there apparently was written documentation that the stalker provided when he originally contacted the hotel that he wanted the room next to Erin Andrews. So there's written documentation in the hotel's records that's what he wanted. Now, whether or not that actually came into play with the process that played out, we don't know. But to your point, absolutely, if you're going to be evaluating this case from a plaintiff's perspective, your thought process is, the jury is going to put a very large percentage of responsibility on the stalker. He's the one who performed the intentional act. So what facts do you have to support a significant enough percentage against the hotel to really justify pursuing this case? Because the stalker's not going to have much money, and no insurance he has is going to cover a claim for an intentional act like this. So these lawyers took quite a gamble here. They believed in their client. They believed in the evidence that they had, but certainly that had to be forefront on their mind as to if this jury comes away and puts 100% on the stalker or 90% on the stalker or 80% on the stalker, unless there is a really significant verdict, that's not going to be an economically justifiable case. So that's part of the initial analysis that they had to work through, and they made a difficult choice, and it looks like it's going to play out fairly well for them.
Well, the jury comes back with 51% responsibility for the stalker, 49% against two hotel companies who apparently both jointly own the properties. They also considered it was a Marriott hotel, but I think it was a franchise, or the group had franchises, so Marriott was not a defendant in the case. Tell our listeners about comparative negligence. Some states have, in other words, in some states you have absolute negligence, where if three people are found liable, that you can go against one or go against all three, versus comparative negligence. Explain that concept to my listeners, if you would, Rob.
You bet. And this area of the law, as you know, has expanded quite a bit. Most states, like Tennessee, like Texas, where I am, the jury is allowed to give percentages on just about any person or entity that may have been responsible. They don't even have to be part of the lawsuit. The defense can ask that on the verdict, the jurors be able to assess responsibility not only against the defendants, not only the perpetrator, in this case, the stalker, but not only against the hotel, who was a defendant in this case, not only against potentially Ms. Andrews, but anybody else that they think might share some responsibility. And the judge in most states has to put those individuals or entities on the verdict form. And the jury then places responsibility percentages, and all of the percentages that the jury lists out must equal 100%. So in this case, for instance, obviously, as you pointed out, 51% went to the stalker, 49% went to the Marriott. Marriott's only responsible for their 49% of the award. If they had only been found responsible for 10%. It's a little bit different. The rules are not all the same exactly, but from a basic standpoint, that's how it works. You're only responsible for that percentage the jury assesses you.
Now, let's talk about the verdict. It was $55 million. I think the defense was arguing that actually, far from hurting Erin Andrews, it made her a national phenomenon, with millions of people going to YouTube and looking at her in her hotel room, and that she became a known quantity where marketability-wise she is worth a lot more. I mean, I think she's a judge on Dancing with the Stars, and she's Fox News reporter, and what they're arguing is many Hollywood types would love to have that kind of publicity because it ups their profile and actually helps them. How would you respond to that argument?
I've heard that quite a bit, and I did follow Ms. Andrews' testimony and a lot of her approach to life after what happened here. I think this was really personal to her. I don't think this was in any way an attempt to gather more popularity. I mean, she was at the top of her game with ESPN. I mean, she was just a step away. But she was the #1 sideline reporter, as you noted from the outset. Her career was already on a very high trajectory, and I don't think she felt like she needed an extra boost here. She had plenty of opportunities coming her way, and she was emotionally distraught over this to the point of physically vomiting, according to multiple witnesses. She took this cause to Washington with her state representative to try to change stalking laws. She's a big sister. She's got a little sister. She seems to be a very responsible, caring individual. And, I think there's certainly some secondary gain that some people try to to motivate in the celebrity world for attention, but I don't think that's what happened here. I think this was about her trying to prove a point and trying to make some change, and I just don't agree with that position.
And I would, those of us who do these radio shows, you generally come in with some skepticism, quite frankly. But I would have to agree with you. I think that she looked very genuine, and from everything I read, was really distraught over what happened to her. And so I think you've analyzed that well, and she was, deep humiliation to see that your privacy is so directly involved and captured where the whole nation can look at it if they want to. Let me ask you this now: the $55 million under Tennessee law, what happens with the judge? That's a high judgment based on variables depending on the individual. Is there a chance for the defendants, the hotel and the stalker, if he, like you said, doesn't have anything, but primarily the hotel, do they have any grounds to appeal a judgment like that?
Yeah, exactly. They have a lot of opportunities. The first thing they can do is file a motion with the trial court judge and say, hey, judge, there was legally insufficient evidence to support an award of $55 million. You need to knock that down on your own and take it down to some other number much less than $55 million. They can file a motion for new trial with the trial court judge on those grounds as well. They can also then appeal it to the appellate courts, which they certainly are going to have already threatened to potentially do, and they can potentially have it knocked down in that regard. There's also a lot of legal dynamics in play here. The verdict is not what's ultimately important. The judge then applies state law to the verdict, and then the judge writes up as what is called a judgment. And it's the judgment which is legally enforceable. That's what you can go down to the clerk's office, get a copy of, and go to the business and say, give me my money, or else I'm going to have the sheriff take your asset. So the defense is going to ask the judge to put in a lesser amount in that judgment. And if he doesn't do that, then they can appeal the judgment and try to have the appellate court knock it down. There are also a lot of state law questions. You and I had previously visited about tort reform, and I'm sure we'll get in and come into play here as well. But the defense certainly has opportunities to ask the civil justice system to reduce that amount.
Well, it's going to be interesting. Then I guess what you're saying is this case is far from being over, and I'm sure we'll be reading about it a lot more in the future. So, hey, Rob, listen, thanks for we're getting the top of the hour for national news, but I sure appreciate you spending some time with us today and putting it in perspective. And you're a good analysis. You're a balanced analytical mind, even though you represent plaintiffs. You give a good balance, and I appreciate that on the show. Listen, have a nice weekend. Look forward to talking to you again in the future.
Thank you, Jim.